The result shall be the exemption base. The exemption shall thereupon be recomputed to take into account the new exemption base. Now, notwithstanding the fact that the assessor receives certification of the change in the level of assessment after the completion, verification, and filing of the final assessment roll. In the event that the assessor does not have custody of the roll when such certification is received, the assessor shall certify the recomputed exemption in a matter authorized by the New York State Real Property Tax Act. The exemption shall be limited to a maximum of $80,000. An increased market value of the property attributable to such reconstruction, alteration, or improvement, and any increase in the market value should not be eligible for an exemption pursuant to this article. The market value of such reconstruction, alteration, or improvement shall be equal to the increased assessed value attributable to such reconstruction, alteration, or improvement divided by most recently established state equalization rate or special equalization rate unless such rate is 95% or more, in which case the increase in assessed value attributable to such reconstruction, alteration, or improvement to be considered equal to the market value. And then all the requirements, I'm going to give you the headlines. 263-23 requirements. No exemption pursuant to this article shall be granted for reconstruction, alteration, or improvements. And then it's section 263-24 exemption discontinuance. In the event that a building granted an exemption pursuant to this article ceases to be used primarily for residential purposes, or title thereto is transferable to other than the heirs or distributes the owner, the exemption granted pursuant to this article shall cease. There's another section of that as well. Section 263-25, time to file application. Any exemption pursuant to this article shall be granted only upon application by the owner thereof on the form prescribed by the state board. The application shall be filed with the assessor of the town of Pomfret on or before the taxable status date of March 1st to be eligible for an exemption to be entered on the assessment roll prepared on the basis from said taxable status date. Improvements to this residential building must be completed, qualify for the exemption pursuant to this article. Section 263-26, effective date. The local law shall be effective immediately upon filing the local law Secretary of State. Let's see here.
Second.
All right, now roll call vote. Trustee Siri?
Yes.
Trustee McKay?
Yes.
Trustee Williams?
Yes.
Trustee Brown?
Yes.
Trustee Brown?
Yay.
Local law is approved 5-0.
And I'm going to keep going. Whereas the village board at a meeting of May 24, 2009, retained the legal services of Gregory R.E.L., ESQ, and Lundberg and Gustafson, LLP, both of Jamestown, New York, for eminent domain proceedings to obtain a permanent easement in and over land of Ronald Nasca in the town of Pomfret, town of Dunkirk, in connection with an erosion control project for projection of the village sewer main, crossing Canaway Creek and lands of the village of Fredonia. Now therefore be it resolved that not to exceed the legal costs without the village board's approval are authorized to be included in the engagement letters as follows. $3,500 from Mr. Yah and $3,000 from Mr. Lundberg and Gustafson. And the mayor is hereby authorized to sign the said agreement or engagement letters as amended by this resolution.
Second.
All those in favor?
Aye.
Aye.
Opposed? Carried.
Be it resolved that a resolution adopted on May 24, 2010, awarding the bid to Reserve Solutions, Inc., Ashtabula, Ohio, is hereby rescinded. Second.
All those in favor?
Aye.
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 Opposed? Carried.
Whereas bids for ferric chloride for the wastewater treatment plant were publicly opened and read on May 19, 2010, and whereas Betsy Sly, Chief Operator of the wastewater treatment plant, has reviewed the bids, has recommended awarding the lowest bid to Camaro Water Solutions, 3211 Clinton Parkway Court, Suite 1, Lawrence, Kansas. Now therefore be it resolved that Chimera Water Solutions is hereby awarded the bid of ferrochloride at a price of $320 per dry ton for the village fiscal year commencing June 1, 2010, ending May 31st, 2011.
Second.
All those in favor?
Aye.
Opposed? Carried.
Whereas a public hearing was duly called and held before this Board of Trustees of the Village of Fredonia on the 14th day of June 2010 on the questions of the enactment of proposed local law number 2 of 2010 of the Village of Fredonia entitled A Local Law Amending Section 287-8A of the Code of the Village of Fredonia to provide for revised water rates, and whereas due proof of publication of the notice of said public hearing was presented to this Board, and whereas said proposed local law was laid upon the desks of the members of the Board of Trustees of the Village of Fredonia at least 7 calendar days prior to this date, and whereas after due deliberation this Board desires to enact the proposed local law. Now therefore be it enacted by the Board of Trustees of the Village of Fredonia as follows. Section 1. This local law shall be entitled a local law amending Section 287-8A of the Code of the Village of Fredonia to provide for revised water rates. Section 2. Section 287-8A of the Code of the Village of Fredonia, last amended on June 8, 2009, with the local law number 3 of 2009 is hereby amended to read as follows. Section 287-8, rates for metered water service within the Village of Fredonia. A, for water supplied by the Village of Fredonia from and after July 1st, 2010, and for each quarterly period thereafter, the following rates are hereby fixed and shall be collected on all water metered services within the Village of Fredonia, a minimum charge of $15 plus from 1,000 gallons to 100,000 gallons at this rate of $2.60 per 1,000 gallons consumption, plus over 100,000 gallons at a rate of $2.45 per 1,000 gallons consumption. Section 3, this local law shall take effect July 1st, 2010. Be it further resolved that the village clerk is hereby authorized to cause notice of said notice of enactment to be published in the Observer as required by law, and be it further resolved that the village clerk is hereby authorized to file local law number 2 of 2010 with the Secretary of State of the State of New York.
Second.
All right, roll call vote. Trustee Siri?
Yes.
Trustee McKay?
Yes.
Trustee Williams?
Yes.
Trustee Brown?
Yes.
Trustee Brown?
Yeah.
Local law is adopted 5-0.
Whereas the Board of Trustees of the Village of Fredonia desires to make certain changes to Section 208-50 of Chapter 208 of the Code of the Village of Fredonia entitled Parking and Traffic relative to the west side of Forest Place, now therefore be enacted by the Board of Trustees of the Village of Fredonia as follows. Section 1. Section 208-50 of the Code of the Village of Fredonia entitled Parking Prohibited at All Times is hereby amended relative to Forest Place by adding no parking signs on the west side of Forest Place between Main Street and Hart Street between the distances set forth below. Said amendment shall read as follows. Name of the street, Forest Place, side west. Location from the southerly curve of Hart Street, southerly to a point 60 feet south from said curve. Area fronts in the vicinity of 44 Forest Place. Name of the street, Forest Place, on the west side, from a point 295 feet southerly from the southerly curve of Hart Street to a point 415 feet southerly from said curve. Area fronts in the vicinity of 22 Forest Place. Name of street, Forest Place, west, from a point 570 feet southerly from the southerly curve of Hart Street to the northerly curve of West Main Street. Area fronts in the vicinity of 6 Forest Place. Section 2, the above amendments shall take effect immediately and as provided by Section 20-2002 of the Village Law of the State of New York, and the Village Street Department is hereby authorized and directed to install the appropriate signage.
Second.
All those in favor?
Aye.
Aye.
Opposed? Carried.
One more.
Be it resolved that the village accepts the payment of $58,592.31 as a refund as per the audit by Computel Consultants, and be it further resolved that the village paid from said payment to Computel the sum of $29,266.15 as per the agreement between the village and Computel.
Second.
All those in favor?
Aye.
Opposed? Carried. Any other resolutions?
Can't have that.